Hi, everyone. Welcome to this edition of July Joseph and Hall Immigration Updates. We actually have a lot of updates for you this week of things that are going on in the universe of immigration. And we'll start with, let's start with Rhode Island with the Supreme Court. Is there any new news out of the Supreme Court this week?
Yeah, so just on Tuesday, a case was decided by the Supreme Court called Johnson v. Guzman Chavez. And so this was about individuals who had previously been removed from the country and then returned to the country illegally or without status. And they were yet again caught by ICE officials and put into detention. And so these individuals, they were applying for something called withholding of removal. And you can apply for withholding of removal if you fear persecution, if you fear that you would face persecution when you are forced to return to your home country. And so these individuals, while they were applying for withholding of a removal, they also applied for a bond for parole so that they would be able to be released while their case was pending, and then they could come back when it was all ready to be decided. But their parole bond had been denied. They were not allowed a bond hearing. And so that was the issue in front of the Supreme Court, whether or not they should have been allowed a bond hearing or whether ICE could just detain them until the entire process was completed. And so the Supreme Court was looking at two parts of the statutes. They were looking at 1226 of the U.S. Code, which is talking about you can get bond and you can be released if you're not a flight risk or you are not a public safety risk. But there's another part of the code that says if you were ordered removed, then you cannot get bond. Now, typically that refers to you were ordered removed in this same proceeding, but these people had been ordered removed before, came back, and then were in the proceedings again. And so they had not technically been ordered removed the second time. They were still in this limbo type area. And but the Supreme Court settled on saying, well, they had been previously ordered removed, therefore they are not eligible for bond. And this can really be a bad situation for people because the withholding of removal cases can take months to years to process and get a final decision. And so they're stuck in detention because they're afraid to return to their own country, and they're in these terrible facilities without the opportunity to even get bond, even if they're not a flight risk, even if they're not a risk to public safety. So it's an unfortunate deciding by the Supreme Court, but one silver lining is that there are not a lot of withholding of removal cases that are decided by ICE. So it doesn't affect that many individuals, but still the ones that it does affect, it's a decision that I'm not too happy about.
All right, excellent. A couple other things I would note about the Supreme Court decision that are just sort of patterns to watch is that Gorsuch continues to come out very strongly in favor of strict interpretation of the statute, meaning like there's no room, if the statute is clear on its face, the agency should not be jumping in and interpreting the statute in a different way. So even though this went against us, what I think is important to point out is two patterns. One is that this idea that the statute means what it says. And that's constantly what we argue in briefs, is that the agency shouldn't be messing around with things. The Congress was clear when they said something, and that's what we should stick to. The same thing, which is sort of related, is Gorsuch's refusal to just abide by this idea of agency deference. In other words, we shouldn't just always defer to the agency because they're the experts in immigration. It's a separation of powers issue, right? If the agency is going so far in interpreting the statute that they're basically warping Congress's intent, then that's a violation of separation of powers. And that's when the courts will step in and say deference is not appropriate in this circumstance. So continue to watch out for this. Gorsuch, even though he was appointed by Trump and he's a conservative judge, this idea of agency deference is something that is very important to the immigration bar and something that we think needs to be changed as well. So watch out for that. Another thing I wanted to talk about, I know we mentioned last week that the EB-5 program would be sunsetting, and indeed it did sunset. Yesterday, the EB-5 program went away. It no longer exists. What does that mean? It means that you can't file an I-526 for a regional center. But note that the EB-5 individual investor program still exists, but the regional center program is what has sunsetted. So you can no longer file an I-526. You can no longer file an I-924 to have your project designated as a regional center. What we don't know is what happens to all the cases that are pending, right? What happens to 485s that are pending based on a regional center? What happens to work authorization applications pending based on that? We don't know what CIS is going to do with cases in the pipeline. As I said last week, we fully look forward to and anticipate that Congress will reinstate the program at some point in the next 30, 60 days. They will reinstate it. So, you will be able to eventually file. We seriously doubt that this will go away altogether, but it does leave a lot of people in a lurch who are planning on relying on the EB-5 program as their way of immigrating into the country. Another big update from this week is the Attorney General vacated matter of LEA and matter of AB. Do either of you want to talk about what that is and why that's significant?
Throw it up to Zach.
Well, basically, for the last 4 years, this started with Jeff Sessions, really. I guess let me back up. So when you go to immigration court, you get a decision, you appeal it. The Attorney General has this special power to just refer cases to himself and to make a decision that perhaps nobody even asked him to make. That's what happened here. We have cases that are involving domestic violence victims, gang abuse, things like that for asylum seekers. And Jeff Sessions said, you know what, I don't need the Board of Immigration Appeals to make a decision on this. I'll make a decision, and said, no, doesn't work. No more. We're not going to have domestic violence victims. We're going to we're going to get rid of gang abuse as a ground of persecution for asylum eligibility. And really, matter of LEA and matter of AB cut off the ability for a lot of people who otherwise would have qualified for asylum to receive asylum. So this is huge. This is opening the pathways for tons of people who have real, genuine fears for their lives to get asylum. So it's a very, very positive, very fortunate thing that's happened.
Yeah, asylum is one of the most, even though it's supposed to be one of the most generous forms of relief. In other words, we're supposed to generously give out asylum if there's a chance of persecution in a home country. The Supreme Court has gone so far as to say if there's a 10% chance of persecution in the home country, you should grant asylum. So it's supposed to be generously granted. But the problem is you can't just get asylum because things suck in your home country, right? You have to show that the persecution you're going to face or you have faced is on account of your race, your religion, your nationality, your political opinions, or because you're a member of a social group. And all of the litigation that we're talking about right now in matter of LEA and matter of AB have to do with that last category of social group. Because, it's pretty easy to determine when somebody has a political opinion, right? But what makes a person a part of a social group? For example, let's say that you were claiming persecution because you're a gay man in a country where being homosexual is illegal. That social group is not necessarily readily visible, right? And so it's not like you can look at a person and say, oh, you're a member of that social group. So proving social group becomes very complicated. Going kind of back to Janet Reno was the first one who certified this idea of domestic violence to herself. And she said, yes, domestic violence is a ground of definitely a social group that qualifies for asylum. And then as Zach said, Jeff Sessions basically vacated Attorney General Reno's decision and vacated matter of AB and then certified that domestic violence is not a ground. So that's what we've been living with since Jeff Sessions. And then finally, the new Attorney General, Merrick Garland, has again vacated and gone back to the Reno position that domestic violence qualifies. But this helps us in litigating these social group claims, which often become very, very difficult in asylum cases.
What does this mean for people that have already had their cases decided with this as the basis for the decision? Is there any possibility that they could go back and have the case relitigated with these cases now vacated?
If it were my client, I would definitely be looking at motion to reconsider based on motion to reopen based on intervening law, especially given the fact that this was the law and then there was this brief interruption and now it's the law again. I think that if it were my client, I would definitely be looking at reopening some of these cases. Mm-hmm. All right. We'll get into the questions in a minute, but before we do, we often, when we talk about our cases, when we talk about the cases that are pending in litigation, we often throw out words with the assumption that you know what we're talking about, right? We'll talk about motions to dismiss and motions for summary judgment and injunctions and blah, blah, blah. And so Zach has taken on the job of kind of breaking that down for you all. And we're going to have a little civil procedure. Civil procedure is a class we all took in law school where we learn all these rules. And Zach's going to give you a little civil procedure 101 class on federal court litigation.
I saw that Lily was kind of acting as a translator for a while, so I figured this might be a good thing to do. This is a class that we take for like a year, so boiling this down into like 5 minutes is it's gonna be tough, but we'll see if we can get all of the I guess nuances explained. So I guess when a case starts, we are initially filing a document called a complaint. That complaint is really saying these are all the things that the defendant, the government in our case, has done wrong. These are the legal standards that you have to judge this complaint by, and these are all the laws that have been broken. Because these laws have been broken, these are the things that we're asking for. After that, we file that complaint with the court. We do what's called service of process. You often see things in movies where people are like, you've been served. You have somebody come up and hand them a document after being in a disguise. With the government, we don't really have to do that. We can just have somebody walk up to their office and give it to them, and we can mail it to them. But that's the next step in the process. We filed the complaint, and then we serve it on the defendants. After service of process is complete, then the government has 60 days to respond to that complaint. And there's a couple of things that they can do. They can answer our complaint, which is basically just a response saying, hey, you know what, we disagree with all of this. They kind of go line by line, and it's not a particularly substantive document. It really says, no, this is a legal conclusion. Okay, this is, we admit this, all the way down, and doesn't really give us anything. The other thing that they can do is file various types of motions, usually a motion to dismiss. The motion to dismiss, it sounds scary, but really it's saying, hey, there's some defect in the complaint that means that this case should not be heard. What we are seeing more often than anything is first that there's a lack of jurisdiction for the court, and that there is that we haven't sufficiently stated a claim that the court can grant relief based off of. So for a court to have jurisdiction, a federal court specifically, there is like very specific things that have to happen. When you are suing the government, there's this concept called sovereign immunity, which means that you can't sue them unless they allow you to sue them. I'm not sure if that's me giving feedback. If it is, I'm sorry, guys. So the government has to agree to be sued for you to even bring the lawsuit. And that's where we find the statutes that we're suing under. We sue under the Administrative Procedure Act, which is basically the statute that says this is how agencies have to act. And what we're saying in a lot of these cases is, hey, the agency has acted in a manner that is contrary to the statute. Here's a statute says, you have to process visas. You can suspend entry of people in certain circumstances based off of proclamations. It doesn't say anything about visas. The fact that the agency is acting in a manner that is contrary to the statute is illegal. And so, Judge, we would like you to set aside this policy or put in place an injunction. Those injunctions is basically an order from the court saying, you can't do this anymore, or you have to do this. It's an order from the court mandating something. We can do it really in a preliminary way. That's the preliminary injunctions that you hear us talk about all the time. And we can file a preliminary injunction before the government's even filed an answer. It's basically where we're saying there's some very emergent circumstances here, very emergency circumstances here. People are suffering, and we need some relief now before the case is resolved. Judge takes our case from the bottom of the pile, puts it at the top, and says we're at the highest priority because our plaintiffs are suffering irreparable harm, because the balance of the equities, because the public interest is in our favor, and because we're likely to win this case. So we put all that on the table. It's a higher standard to meet than even winning the lawsuit, and it's why sometimes it's not worth, I suppose, doing that in every case. It's kind of a calculated decision to have the judge look at everything right at the beginning before we can really develop the record, before we can get the documents from the government that kind of show their internal policies and things like that. But basically, it's at the beginning saying, we need relief now. That's what happened in Milligan. That's where we said, hey, it's been months since processing has been happening, and Judge, there's this illegal policy that the government is utilizing to deny visa adjudications. We need relief now. We need you to say right now that visas get adjudicated. And the judge did. He said, hey, I've looked through this. I've looked through what everybody has said, and I'm going to grant this preliminary injunction, this thing at the beginning of the case, saying, okay, you have to be adjudicating cases, and you can't deny or refuse to adjudicate a case just because it's in a proclamation country. But again, the standard there is a lot higher than it is in a regular, win the case type of motion. We have to show that we are, substantially likely to win on the merits. We have to show irreparable harm, to balance the equities of the case. It's a more difficult standard, and it's not always ideal to do it at the beginning, because if you lose there, it kind of sets the tone for the entire rest of the case. You've already had the judge say, I don't think you're going to win on the merits here. And you don't want the judge to be looking at your case the entire time, as if you have already lost. So where there's not like, this immediate emergency need, and where it maybe is not as clear cut, sometimes we don't file those preliminary injunctions. So we've gotten the complaint filed. We've talked about the potential for a preliminary injunction. The government can file these motions to dismiss, and a motion to dismiss is really just asking the court. It's a motion moving the court, saying, hey, court, I would like you to dismiss the case. It's not saying that the case is dismissed. It's not saying that the processing is ending or anything like that. It's just a request to the court to stop the case because of X or Y reason. And in our case, it's because we are the Department of State, and the Department of State is immune from judicial review is really what they're arguing. That's not true. So we're not particularly worried about these motions to dismiss, but that's what they're filing. They're saying, you're not stating a claim that you can get relief on. And by the way, we're the Department of State, and judge, you can't say anything to us. The standard there is very much in our favor. We're in the preliminary injunction sphere. We're really, having to meet a high bar. On the opposite side, the motion to dismiss spot, the government has a very high bar to meet. So when we're responding to these, it's scary that they're there. I know it sounds scary that the government's asking to dismiss the case, but the law's on our side and the standards are on our side. After we've gotten past that, we're past kind of like the preliminary part of all of the lawsuits. We reach the actual litigation. First thing that normally happens is we kind of discuss with the government a schedule of when everything will be briefed. Most cases that we have filed right now are not even at that stage. But it's where we kind of talk about, okay, you'll produce the record on this date, we'll file this motion at this date, you'll respond on this date, and then we'll give to the judge. It's a joint report saying, this is how we'd like the case to proceed. And the judge normally says, okay, sounds great, we'll have it proceed in that way. That's what we've been seeing in like for Kinsley, for example. We said, okay, this is how we'd like the case to proceed. Government will produce the record on this day. We'll file our motion on the 11th. they'll respond on the 23rd. We'll respond to that response on the 7th, and so on and so forth. So we have this kind of schedule in place. If at the end of that, we want to, or the judge wants to, we can have a hearing where we actually have, arguments in front of the judge or answer questions with the judge, but it's not required. And the lack of a hearing doesn't necessarily mean anything one way or the other. It could be just that our briefs were extremely well written and the judge has no questions. It also means that we're not constantly going in front of the judge and saying, hey judge, this particular plaintiff is having issues, or hey judge, this consulate is having issues. There can be situations where the judge wants status reports, and that's what we saw in Milligan, for example. The case was stayed, just put on a pause for a bit while things were kind of resolved in a more informal manner. But along the way, the judge got these status reports that we put together with the government, saying this is where the case is at, this is where the case is going, this is the number of people who have gotten appointments, the number of people who have gotten their visas, and so on. But really, we don't go in front of the judge unless a hearing is scheduled, and that doesn't happen too frequently. There's a couple of times in a case that you'll go in front of the judge, and that's about it. So that leads us, I suppose, towards the end of the case, which is where we're at in some of these, where we're actually asking for a decision on the merits of the case. This is what we call a motion for summary judgment. You're saying, I would like you to make a judgment summarily across the board. What you show for that is that there's no facts that are in dispute and that the law clearly favors you. It's really just a kind of like a trial, but on paper. So we file a motion for summary judgment saying, all right, here are the undisputed facts in this case. In a case against the government, it's pretty easy. We say, here's the record they produced. But there's no denying that this is the record. And here's the law. And put the facts with the law together, you see that it's illegal. And that's the big argument that we make. We go, all right, here's the facts. Here is the law. 212F says that the president can suspend entry and not visa issuance. Because of that, let's kind of put these together, find some cases where other judges have kind of reviewed similar facts to give you kind of an idea of where to go with this, and in the end, make a judgment for us summarily across the board without a trial that we win. That's where we're at with Kinsley right now. So we filed a preliminary injunction or motion for summary judgment in the alternative. So we're saying basically, hey, we win this case, but if you don't want to make that decision right now, we at least need you to step in and make some sort of preliminary determination that we're going to win the case and put a stop to this practice as we kind of develop the record and develop the case a little bit more. And the judge can make a decision either to grant that preliminary injunction and have the case keep moving forward, deny the preliminary injunction, I suppose, and have the case move forward, or grant the motion for summary judgment, either for our side or the other, saying, hey, I've reviewed all the facts, I've reviewed all the law, and I think that plaintiffs are right that the statute absolutely does not say that visa issuance can be suspended. So you guys win. And at that point, case is over. There's an order in place from the judge, and the Department of State has to comply with it. If they fail to comply with it, then we'll get a contempt motion in place. We'll get, there's a whole bunch of things that we can do if they were to fail to comply with it, but they won't. That's the government, and they're going to comply with what the judge says. Yeah. Any steps I missed along the way, guys? Kind of rambled through that, I feel. In my attempt to get it done in a fast manner, but
the only thing I would add is, like, for example, on the Milligan case, when we got the preliminary injunction, the government filed what's called an interlocutory appeal of that injunction. So an interlocutory appeal means it's an appeal that takes place in the middle of a case, right? A judge makes a particular order, and you're appealing that particular order. So it's not an appeal of the overall case; it's an appeal of the preliminary injunction. So that is up on appeal right now at the DC Circuit Court of Appeals. But what's happened essentially is that we've just delayed it, right? We just keep delaying the appeal because the motion to dismiss is pending. If the case is dismissed, the appeal sort of becomes irrelevant, right? So another thing that can happen in these cases is appeals. What the government can also do when they file an appeal is seek a stay. So they can ask the circuit court to stay the decision of the district court granting the preliminary injunction. They did not do that in this case. I think they were concerned about getting a published decision out of the circuit court, which would basically be binding on all the district courts in DC. So they chose not to file a stay, but the case, the preliminary injunction is on appeal right now. Similarly, when the case is over, the government can appeal a negative decision to a circuit court and seek a stay of the decision while they do that. So, all right, anything else on civil procedure before we tackle some questions?
Unless there's any questions about civil procedure, let's jump on in.
All right, let me go back to the comments here. All right, let's start up at the top. Hi, Charlotte King is the first one to comment here. She says, hi guys. And Charlotte is, if you don't know, is the lead plaintiff in a case we filed yesterday. Was it yesterday? Time is like leaving me right now. I think it was yesterday that we filed the London mandamus case. Over 100 plaintiffs suing the consulate in mandamus, the consulate in London in mandamus over refusal to process K1s in a timely manner. Any updates on the K1 Egypt lawsuit? Rylan, this is all you, right?
Well, I'm the spouse when we keep getting these mixed up. Jennifer's doing the K1 Egypt lawsuit. I think she responded to the motion to dismiss.
She did. So the government filed a motion to dismiss 22 days ago, and we filed our response to that yesterday. So now the government has, I think, 10 days to reply. Is that right, Zach? I think they have 10 days if they want to reply, although the rules really kind of require them to seek the permission of the court in the absence of an agreement to the contrary. We don't have an agreement in this case. So not sure at this point whether the government will reply or not. And now we just wait for a decision on the motion to dismiss. Another sort of point here is that we are going to move for summary judgment on this case now. The reason that we're comfortable moving for summary judgment on this case is because the plaintiffs are all very similarly situated. It's not like we have disparate groups of plaintiffs that are in different situations. For the most part, they're all in the same situation in the K1 lawsuit. So we will be filing the motion for summary judgment, as Zach explained, asking for a final decision on that case in the near future. All right, we already talked about this. What's the perspective on the future of the EB-5 program? Well, the regional center program, at least momentarily, has no future. It doesn't exist. But as I said, we fully intend that Congress will reinstate the regional center program. It's happened in the past. It usually happens in August or September. And if it does happen, believe me, we will notify you. All right, here we go. Rylan, this is you. Yeah. This is the spouse's case. Any update on the spouse's case?
Yes. So I'm sure many of the plaintiffs are already aware, but we did get the motion to dismiss in this case, but it was more than just a motion to dismiss. It was also a motion to stay. That was the first thing that the defendants were asking to do. And in the alternative of stay, they would dismiss. Or
what's a motion for stay, Rylan?
A motion to stay is to say, hey, so they were specifically saying all the plaintiffs in this case have been scheduled for an interview in September. So let's just make the court stop listening to this discussion, because this could all go away in September. Let's wait until after their interviews in September, and then let's proceed with the case. And so that's what they were trying to do with that motion to stay. They just wanted to delay the case until after the interviews were done. And they also filed concurrently, they filed a motion to dismiss and a motion for summary judgment. So our plan right now is, because we think that it's unlikely that we're going to get something better than interviews in September.
Well, not only that, we actually asked the U.S. attorney for interviews in September, and we got a very abrupt reply saying, no, we'll file on Monday. So there's no way we're getting, absent cancellations, we're not getting any earlier dates.
Yeah. Yeah. And so we think right now, with all our clients already scheduled for an interview in September, that's a really good thing for our clients, because there's still 500,000 people waiting to get in, and to have an interview scheduled at all is a really good thing. So we also, instead of risking it, instead of trying to fight the motion to dismiss or pushing for summary judgment, we would also like to stay and hope that the court will just let this be. And then if any of the interviews are not scheduled or delayed, or if there's any funny business by the embassy in September when all our plaintiffs should have their interviews, then we will again get back onto the bulldog mode and say, hey, you scheduled them for this date. Why aren't you doing it? This is, again, an unreasonable delay, and it'll make our argument look that much better. And so that's our current plan right now.
Yeah. And, I know that plaintiffs are going to be out there screaming and yelling. That's not okay. We want an earlier date. The truth is we would lose. If we push this and we try to argue that, no, it's not reasonable that they're delayed until September, the judge is going to deny the case. The judge is going to say, the government's trying their best. They've scheduled you in September. Stop complaining. And he would dismiss the case. So for very many reasons, we will not be filing. We will be we will be agreeing to the stay in this case. All right, next one. Let's see. Tiffany, I'm not sure.
She is also a Cairo spouse.
Okay, got it. All right. So does it change the timeline? I think we just explained that, right? I mean, we anticipate that all of you will be approved in September, on September 13th, and get your visas, and then we will dismiss the case. If there's cancellation, you should still be asking for cancellations, right? You should still be emailing and saying, if there's a cancellation, I'd like an earlier date. But as far as pushing for an earlier date, we tried that. It's not going to work.
Yeah.
All right. Let's see. Penn v. Blinken. Is there any update on Penn v. Blinken? This is the Rio case. That is who's the lead on that?
Also Jennifer.
I think that's Jennifer as well.
I can give an update. I think that, I mean, I'm not sure if we've received the motion. We have received the motion to dismiss. That one I do know. But as far as I suppose plaintiffs and where they're situated, we're seeing interviews, not as many as we'd like, of course, but I'm looking at the update form right now, and I see a handful in June, I see a handful in July. So people are being scheduled. It's just kind of happening at a slower pace than we would want it to. We'll respond to the motion to dismiss. Again, it's kind of like we're receiving in every single one of these cases. We're not particularly worried about it because, again, the standard that the government has to meet to dismiss the case is a lot higher than winning the case at summary judgment, or when they're fighting back against a preliminary injunction. So as we're responding to this motion to dismiss, the plaintiffs will continue to be getting their interviews, and things will just keep moving along.
You're muted.
This may be another one. We need to look at the plaintiffs, but maybe another case where we consider filing a motion for summary judgment. Okay, let's see. This is a good question. What's the difference between Go and Gomez? If Judge Mehta decides to reserve visas for Go, will it take a year to be final like Gomez? So let me give context first of all. Gomez was the DV 2020 case, right, where we challenged the government's refusal to process DV 2020 visas before the September 30th, 2020 deadline. And our case was a companion case to Gomez. We had the Acre plaintiffs, which were just DV 2020 plaintiffs. All of our plaintiffs have received their visas, and it didn't take a year. They all got their visas. So the government was moving on those cases, our Acre plaintiffs, while we filed the case. The reason that Gomez is still out there is because Gomez doesn't just involve DV. It involves all types of immigrant visas. And so it was a very broad-based challenge to the visa ban. And so the Judge Mehta's order was limited to diversity visas. In other words, he didn't grant the preliminary injunction for anybody but DV 2020. And that's why he reserved those 9,000 visas, is because that's really the only remedy he was willing to go give. And so Gomez is still out there because there's still live issues. What do we do about the other plaintiffs that haven't been adjudicated? So that's what's going on there. Go is different because, again, first of all, Go is just DV 2021, right? So it's a specific type of class, and we have precedent, right? We have Judge Mehta's precedent on DV 2021. So it's actually very similar to the Aker case, less similar to the Gomez case, more similar to the Aker case. And, it's our hope that he'll make a decision very similar to what he did in the Aker case, and that he'll reserve sufficient visas, at least for our plaintiffs, but ideally for the rest of the world as well.
I would say another big difference is just the timing of everything. With Gomez, I mean, COVID was going on. I mean, we were in the height of it. So Judge Mehta was very sympathetic to the fact that, the consulate had been closed and they were operating under, pandemic level COVID outbreaks across the world. It's been over a year now, and now we've had since September for I guess October for DV 2021 to be adjudicated, and we're seeing that's just not happening. So the other big difference, I think, is now we can really show, like, hey, the government's just really not doing their job. Whereas before, the government could say, hey, come on, it's COVID, what do you want us to do? Tell me, Jeff.
Keep doing that because I'm worried that it's me that's causing the feedback. But another difference that triggered my brain when you said that, Zach, is we filed the DV 2021 case way back in November, right? So, we have a hearing coming up in July, and we're going to be like, Judge, we told you, we knew this was going to happen. We filed 2 months after the new diversity visa cap because we anticipated this was going to be the situation we're in. And here we are in July, 2 months before the deadline, and there's been, 6,000 diversity visa cases processed worldwide. That's just not okay. So I think this case is actually much stronger, or our position is much stronger than we were in the Aker case. A related question, what kind of action are we expecting to see from Judge Mehta? Who knows? Who knows? Judge Mehta knows the issue. He knows the September 30th deadline, right? So he's either going to, if we win, he's either going to order the government to approve those visas before the September 30th deadline, because the government's position is they don't exist after that date, or he's going to order the government to reserve a certain amount of visas, or we're going to lose, right? So who knows what action we're going to see. I don't think we'll get a decision on the date of the hearing. In fact, I'm pretty sure we won't. But I would anticipate that we would get it shortly thereafter because of the timeline. All right, will there be another lawsuit in the UK? No, we just filed this one yesterday. So I don't think we'll be filing another one soon. It could be that we file a motion to add plaintiffs, but we would only really do that if there were plaintiffs that got missed in the first round. So if you're interested, put yourself on the wait list. On the Siskin and Susser website, there is a wait list, and you can sign up for it just in case we file another case or add plaintiffs. Can't we insist the government attorney process at least for those who are documentarily qualified? Everybody is documentarily qualified. Unless you just got to the NVC, every one of our plaintiffs has been found to be documentarily qualified. So, that really doesn't help us. The NVC is the NVC, and they're part of the Department of State. So what you're asking is exactly what we're doing. We're insisting that they process the visas for everyone that's documentarily qualified. Okay. Any update on the Brazil lawsuit? We talked about this. That's the Penn case. She's glad that we're going to agree to the stay. How does the outcome of Ramirez v. Blinken affect the Milligan round 2 or round 3? This is a good question. So we have Ramirez v. Blinken, which is the challenge to Manila, right? So Ramirez is Manila, but we still have Milligan round 2 and round 3 plaintiffs that haven't been adjudicated either. And my answer is both help, right? If Ramirez gets decided first, unless we lose Ramirez, which is possible, I suppose, but if we lose Ramirez, it's a different judge. It'd be persuasive only to Judge Boasberg in Milligan. It would be persuasive only. But, we would have then a decision going the other way. As of now, as far as I'm aware, we only have one decision out of the DC district that's gone the other way, and that was in the EB-5 context. Is that correct, Zach? Is that what you understand too, in terms of proclamation challenges?
Yeah.
So there's one decision already out there that's bad. It's called LEA v. Mayorkas, and it's bad on mandamus. But every other case that's come out, and there's been several of them, have been positive for us. So if Ramirez is positive, it will be something that we can then show to Judge Boasberg. We would file a notice of related case, and we'd file it with Judge Boasberg, showing him that one of his brothers, one of his colleagues or sisters, colleagues, has granted a mandamus in an exact same situation. And if Milligan goes that way, we would file that same motion in Ramirez. So it would only help if it's granted.
I'll also say along the way for Ramirez, we'll get some internal communications between the Department of State and the Manila embassy. So, we'll kind of get a more inside view about what's going on, and that'll only help for a summary judgment motion in Milligan.
Yep. All right, last question here. NVC refuses to send the case to Rio. What will happen? What will need to happen to force their hands? We can't get an interview until it happens. Well, the first thing that we've been advising people to do, and will continue to advise people to do, is if you email the NVC, copy the consulate, put in the consulate's email as well, so that they can't blame things on each other. So the consulate can't say, well, you need to talk to NVC. They haven't sent the file, right? If you're copying both of them, they can't blame each other for the lack of action. The second thing is, what will need to happen to force their hands? We need a victory. We need one of these cases to win, because if we win Ramirez or we win Milligan, the order is going to apply to the Department of State and all of its constituents. And the NVC is a constituent of the Department of State. So that's what we need to happen, is we need to win. All right. Why don't we ever see Aaron and Zach on the screen at the same time? Are they the same person? Thank you for all your work, especially on Kinsley and King.
Aaron's a lot taller than me. So
don't give it away, Zach. Don't give it away. Nobody can tell.
This is how Aaron gets away from any responsibility. He changes his last name to a new last name.
Mm-hmm.
Because my last name's new.
No, Aaron was going to join us today, but he is busy on the Go case, working on the Go case, which is due tomorrow. Our response is due tomorrow. So he's working on that for you, and took the day off. So thank you all. Thanks for being here. Have a great long weekend, 4th of July. Celebrate independence. For those of you who are here in the U.S. waiting for your spouses and fiancés, have a great 4th of July, and we'll see you next week at this time. Thanks again.
Bye.